Court is now back in session. The Honorable J. Cedric Simpson presiding. Court does call the cases of Judy Weinberger versus Cotterman. Two cases. That's case 22C 2412 and 22C 1321. Counsel, state your appearance, please.
Good afternoon, Your Honor. Welcome to court appearing on behalf of Judy Weinberger, and Ms. Weinberger is present, Your Honor.
All right. Right. All right. Very good. Before we go much further, Aaron, you had presented to the court the MSHA audit log. That is all of the notes from that. Is that correct?
That's correct, yes.
And my understanding is that there was, at least my review that indicates there was a payment that covered, I think it was a previous CERA payment that covered, I thought it was January, February, March.
I believe that's correct as well. Looking that record up now.
I think it was June 1st. Is some indication of that.
So the initial application in this case was approved on 12/23 of last year.
Yes, sir.
I'll see if I can pull up that particular application. I don't know if you need numbers or.
Well, I don't. Yeah, I may need numbers. Yes, sir, if you can.
For the initial application, which was approved on 12/23 of 2021, the arrears were $3,000. Future rent was $2,850, and then other housing assistance was $300. Electric was $702.38. And it's all broken down, so I don't have a total for that, unfortunately.
No, that's okay. And that was on what date, sir?
That was approved on December 23rd of 2021.
Got it. Which actually would make the, yeah, right. The 2850 would have been those amounts covering January, February, March.
I believe so, yeah.
That makes sense. Okay. Have there been any other payments? I did not see any.
Not from CERA. The review for the recert is ongoing.
Got it. Okay. Unless either side had any other questions for Aaron, I think with this log and everything, I think we could probably let this gentleman go. Mr. McCoy.
Well, I don't see the need for any questions regarding Aaron at this point, but I don't know if I would need him, Your Honor, depending on how in-depth Your Honor wants to go with the CERA will determine whether or not we will need him to call him and follow up with him.
All right. Well, before I let you go, Aaron, and Ms. Cotterman, can you think of any questions that you might have for Aaron from CERA?
So my DTE is still with the CERA, and since there's no response from Ms. Weinberg, what am I what's going on with my DTE and my pressure and stuff? Or like
Currently, the whole process is ongoing. That's probably the best that can be explained. I guess part of my concern is, does the ledger that you have, Mr. McCoy, reflect that she is clear through March? At least.
That's my understanding is that she's clear through March. My client has been paying the electric bill since, I won't say the end of the lease.
Well, that then becomes the other issue. Aaron, is there a lease that was presented to CERA or Hawk, whoever had this? It might have been Misha at some point. It's brought back, but
You're asking if there's an updated lease, Judge?
yes, sir.
Give me 30 seconds to check that. The only lease agreement I see in here is one that was uploaded on January 26th of this year.
Of 2022.
That's correct.
All right. All right. Wait, Aaron, I think what I would do is I'd let you go while we work this through. And then if we need you, I can have my staff maybe email you or something. Okay.
Very good, Judge. I'll be around.
Thank you, sir.
No problem. Have a good day.
You too. All right, folks. Couple of things I think that are important. The first being that we really have to figure out what was meant by the lease, and that was sent. Yes, sir.
Yeah, if I may, I had prepared a brief of the issues I thought that based on the information we had at our prior hearing, and I wanted to present the court with a copy of it and also the defendant with a copy of it.
Are you looking through that, ma'am? Well, I will just say this while Ms. Carterman is going through that one of the issues I think that is important is that when were the notices sent? Right, but hold on one moment. Let me just see the ones that were filed with the court.
The notice for possession, the recent notice was August the 5th was a notice for the notice to quit. And the complaint was filed August the 11th.
Well, the first thing is in case 1321. What's clear is that rent was paid through March. Of 2022. Right? So the landlord agrees upon accepting of those payments that they won't initiate termination of the tenancy for a 30-day period. And what is at least clear is that Ms. Weinberger did not wait those 30 days because the notice was they served upon Ms. Cotterman on April 28th of 2022. That's in regard to the, I guess, the non-payment case. On the other matter, then there was a new notice August 5th of 2022, but subsequently, I don't have my notes with me. Ms. Cotterman, what was the date you received the lease or purported lease via email?
July.
Do you recall the specific date? Pardon? Okay, go ahead. It's in here. In my notes. Oh, we did. You're right. Never mind, ma'am. I think I have a copy of the printout. I did get that from you, I think. No, I remember seeing it. It was July 9th. So ultimately, the real issue in that regard is going to become on July 9th, there is a document that is purported to be a lease, which again is a bit odd because the landlord signed the lease and now says that the tenant did not.
I believe that's the issue before the court, Your Honor, whether or not there was a valid signed lease. She never received a signed lease. And the lease that she provided on July 9th was through a system called DocLoops, where it's an electronic signature. She presented it to the tenant, and the tenant, all the tenant had to do was sign a lease and it would go directly back to her. She never did receive the signed version of the lease.
Ms. Cotterman, would you agree that you didn't sign that?
I had printed it out and signed it and then mailed it to the US Postal Service.
And I guess my question then becomes, Mr. McCoy, why was a lease sent to her in the first place?
Your Honor, my client sent a lease after expiration of the old lease because the tenant was still in premises and the premises was being repaired, and the case was before the court based on the repair that was going on. And reason she sent the lease was that she wanted to see if it was a month-to-month lease. And this was, she didn't know how long this case was going to be before the court and how long the appeal was going to take. And so she sent the lease hoping to receive payment from CERA while she was still in the premises, because she was not only not receiving any monies, she had not received any money since March, but she was also beginning to pay the utilities herself. And she was losing rent from that unit in the unit below where there was damage, water damage to those premises from a snake being stuck in the drain of the tenant's unit. This Carter.
So so your client in why was your client in June? Why was your client in June claiming that Ms. Cotterman owed February, March, April, May, and June?
Why was my client? Gunnar, that issue was a big issue at that point
Why?
because the issue was before the court and it made a determination about those months. And my client.
No, I don't know that I did.
Well, I think the court made a determination of indicating that it could be some fraudulent transactions when the court introduced the whole concept. When that concept was brought before the court, my client moved on from that and was talking.
Well, but hold it. She represented to CERA that she gave Miss Cotterman money. Did she or didn't she?
That she gave Ms. Cotterman money, Gunnar,
Yes.
based on the court's determination.
No. Mr. McCoy, I'm not asking about my determination.
Well, I'm telling my client not to respond to that question because the court made.
Well, if you're telling them not to respond to the court question, then we're going to have a problem here, Mr. McCoy. We're going to have a problem.
Well, the question that we're dealing with is.
We're going to have a problem, Mr. McCoy, because, hold it. You can play games all you want. Your client represented to CERA that monies were given to Miss Cotterman. That represent something very different than what you're telling this court today, that she was paid through March, that she was paid through March.
Yeah, my client indicated to the court at the time what the transaction occurred, and the court indicated that if the client spoke of those kind of transaction, she could be held in a fraudulent transaction. So I'm saying to my client that I recommend that she does not respond to an issue that would put her in jeopardy of a fraudulent transaction.
She represented, as of June, that Ms. Cotterman owed $5,000 to her.
I believe, Your Honor, she was talking about from March until September. If you look at the months after March, you got.
Mr. McCoy, let me do this so that we don't really run into a problem. Can you make me a copy of this before we start with all of these representations, failure to answer and the like, because I'll put your client under oath. Now, if she doesn't want to answer it, seeking some Fifth Amendment issue, then that's fine. I mean, if that's the reason, she can certainly do that. But it becomes very difficult to then, for this court, if that question's not going to be answered, for me to believe anything she's telling me. I'm just going to let you know how I'm viewing it. Because those funds came in. A representation by her counsel was made today that it was paid through March. I'm looking through the documents from CERA that clearly indicate she represented that she gave to Ms. Cotterman at least February and March, and then represented to CERA that there's $5,000 owed in June. And all I'm trying to figure out is what is the truth.
Yeah, I think she was representing that the monies that was owed was after March, and that was April, May, June, July, and August, which was 5 months. And then
Mr. McCoy, before you say any more, I'm going to let you see what I'm looking at, because that can't be true. And before everybody gets in trouble representing something to this court.
well, yeah, my question to the court is, if we're talking about the issues in the past, we're talking about unnecessary issues. We're talking about possession today, which is based on a complaint that was filed August the 5th.
I have 2 complaints. But if you're asking me, I mean, Mr. McCoy, your client, did we get one for Miss? That's okay. She can have that one because I do have a copy here. And what I'm going to do is, let me get you to the right part, because I'd like you to look at the ledger entry on June 11th. You see which one I'm talking about?
Yes, I'm reading. Your Honor, my client adopts that statement on 6/11. That was discussion that was with CERA regarding funds that were paid. And she understood that to mean that whether or not Ms. Cotterman had paid her since then, paid her any money, and she told CERA no.
I don't know what that means, because the last line says, so as of June 11th, she owes me 5 months rent, February, March, April, May, and June.
That's correct. Now, she said that they asked her whether she had told them that she had received monies through March, and she had not actually received the monies from January, February, and March. Those monies were given to Ms. Cotterman for her to leave the premises. She does not dispute that statement. But when CERA talked to her, they asked, had Ms. Cotterman paid her any money, and she said no.
Responded to seeking requests. Chelsea Cotterman requested, this is June 11th, requested to leave and canceled her lease in January 2020. I agreed. She asked for CERA money for February and March to assist her in finding a new place. She signed a letter stating that she would move out on January 31st. I gave her the money. Copy of letters attached. She then refused to leave and denied that she received any money. So as of the date of June 11th, she owes me 5 months rent. So is it, I mean, we better think carefully about how to answer the question. Is it plaintiff's position that money that was paid over to rent, she paid to Ms. Cotterman?
I believe she indicated in that statement she did, Your Honor.
And that's where we're going to have a problem. She can't do that, even if she wanted to.
Your Honor, we went through that whole scenario in court, and this court indicated to my client if this characterization occurred like that, she could be involved in a fraudulent transaction.
Yes, absolutely.
And what I am saying to the court, we moved on past that issue.
I'm sure you did.
And brought up other issues with the court. And if the court is trying to go back to those issues.
Oh, I'm going back because I still had the case pending before me. So don't say the court trying to go back, that the court ruled on this. Don't try to do that, McCoy. That's not going to work. If she committed fraud, she committed fraud. She can't, the CERA funds, you cannot receive them and then pay them directly to the tenant. It can't happen.
My question to the court is, once the money is given to the landlord, is it the CERA funds or the landlord's money?
Her ledger has to reflect what was given to the landlord.
Got it. The landlord can do anything they want with monies that is considered.
No, they can't.
Got it.
They can't, Mr. McCoy. Don't even try to make the argument. They can't do it. Because otherwise what you would have is a circumstance where people were paid CERA money, just move into a unit, pay me the CERA money, or at least I as a landlord can say you're living in the unit, get the money, split it with you, you go on about your business and on your way. That's to go to the payment of rent. It's just like when tenants, where landlords were not participating, would receive funds. If they did not pay that over to the landlord for rent, the tenant was in trouble.
Got it. The situation is this, is the tenant stayed in the premises through March.
Right.
And the monies that she received was applied for that time period. Now, this is why it's important for us.
But she, okay, Mr. McCoy, just plain and simple. If she gave the money to Ms. Cotterman, the money wasn't applied to rent.
Ms. Cotterman is still in the premises, John.
No. Your client indicating that Ms. Cotterman got at least a 2,000 or more windfall.
My client has moved beyond.
I know she wants to move beyond, but if somebody's committed fraud on the CERA program, we're going to have a problem. I don't know how many times I can say it. You can spin it however you want to spin it. It's not going to spin very well here. I'd be saying the same thing if the payment had been made directly to Ms. Cotterman and Ms. Cotterman doesn't pay the money over to the landlord for rent.
Well, what responsibility does Ms. Cotterman have if the money was paid to her and she didn't didn't move, or she kept
She can't move. That's the problem, Mr. McCoy. The transaction that your client lays out on June 11th, can't happen. Well, it can happen, but it can't happen. Not legally, it can't happen. That's my point.
Well, that's why I wanted to keep Aaron around so we can talk to him about the transaction.
Get it back, because if we got to get it back, because that transaction, she can't do it. The funds were paid, Mr. McCoy. The funds were paid over.
And she has stayed through the end of the lease now. She has stayed through June 30th.
You know, email him, because apparently what I'm saying is not making sense to somebody. She can't pay. So here's the thing. Telling me she's paid through March. When did she pay that? This was the very first thing you told me. I'm not playing this shell game. I've got to figure out exactly all of the issues that I'm dealing with. I said, is everything clear through March? You told me, yes, she's paid through March. She didn't. If you're saying that you paid the CERA funds to Ms. Cotterman.
Ms. Cotterman is saying she didn't receive the funds.
Then why is your client representing that she paid it to her? Why is Mr. McCoy? Doesn't matter what Ms. Cotterman's saying. I'm asking why your client's representing what she's representing.
My client is making a statement. That statement she is supporting what it paid. document that was signed, and if that document is disagreed with, what other proof does she have to present?
She who?
Client presented a document saying that Ms. Cotterman, who Ms. Cotterman signed, saying that she received.
Then why, if that was the case, Mr. McCoy, why at the very beginning of this hearing, if that is all true, then why at the beginning of this hearing is your client indicating that she's paid through March?
She adopted the fact that that was a dispute, that that whole issue of
Mr. McCoy, I'm not playing this game. You can't sit up here in the very beginning and sit up here and try to tell me, is everything clear through March? Yes, she's paid through March. Then when I go to June 11th, your client is making representations to a program that she paid Ms. Cotter, and making a representation to that program that now Ms. Cotterman owes her for 5 months. And then say, well, we're just beyond that. No. We're not beyond that. If she, bottom line, if she took the funds and fraudulently used them, then you got another problem. If she didn't, then I want to know why she made the fraudulent representation to CERA. Those are the options. And you may not like them. You can try to spin it all you want, but those are the options.
Well, I'm saying the issue that's presented to the court today.
The issue is what I say it is, and that's my issue. It may not be something you want to deal with, but that's my issue. And so I want to know what is true.
Your Honor, my client adopted the statement that was presented on the 6/11/2022 that you presented to us that we just looked at. My client adopted that statement.
So she gave her money.
My client alleges she gave her money. She made a statement. She has a statement from Ms. Cotterman saying she received the money and she was leaving the premises. So I don't know how much more detail the court wants to know about whether or not she received the money and whether or not there was a fraudulent transaction. Our contention is that January through March, the period that the money was paid.
How much does your client claim Ms. Cotterman owes?
Well, Your Honor, she was seeking money damages from April through.
That's
September.
this case. How much, what does the ledger show Ms. Cotterman owes?
April through September. Well, that's $6,000.
And why was the new lease? What was the new lease for?
As I indicated earlier, Your Honor, the new lease was dated July the 9th. Following the expiration.
What was it for?
What was it for? Because the tenant was still in the premises after the expiration of the old lease. she had presented the new lease, and it's a month.
Mr. McCoy, wasn't the new lease initially to be able to present to CERA?
I don't understand what the court is asking.
In order to receive CERA funding, there has to be a lease. Isn't that really the reason your client generated that lease?
She generated that lease, yes, because she didn't know how long the tenant was going to remain in the premises, considering it was damaged. There was damage to the unit, and the case was still in.
Not my question, Mr. McCoy. Your client generated the lease to ultimately present to the CERA program because she had to have a new lease. Isn't that, Mr. McCoy, the lease that was sent to Ms. Cotterman was generated for the purposes of obtaining CERA funding. Isn't that true?
Yes,
Counsel, you know what? I'll tell you what, let's just get beyond this. I want her under oath and I want her under oath.
You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth. State your name incorrect, first one.
My name is Judy Weinberger, K-U-D-Y-W-E-I-N-B-U-R-T-R.
Solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. State your title, your official one, and vote for the.
Chelsea Cotterman, CHELSEACOTTERMAN.
Was the lease presented the January or the July 9th lease or the July lease that was prepared for the purposes of submitting to CERA? Was it not, Mr. McCoy?
yes, Your Honor.
That's why a copy went to Ms. Cotterman and also ultimately was going to go to CERA. So then my question becomes, let me ask this. Was your client aware that she couldn't evict while in part that process was going on? And that after receipt of any funds, she couldn't begin an eviction process?
Your Honor, in response to your question, you're asking me if my client was aware that if she received, if she presented the lease, she couldn't evict her if she received the funds.
No. Yeah, for at least 30 days.
Well, at least 30 days. Yes, I believe my client was aware that when she initiated the lease, it was a month-to-month lease, and she was going to present that to CERA once it was signed and presented to her.
Okay. And if in July that were the case, why do I have a notice at the beginning of August?
Because she never received a copy of the signed lease.
Okay.
And she still, to this day, she does not have a copy.
And Mr. McCoy, why would I not have a Park Forest of Blackman issue?
I don't understand that.
The landlord cannot act in a way to have the tenant believe that their tenancy continues. So if on July 9th, she sends out a lease, the tenant signs it, drops it in the mail. Whatever sours between then or not, the tenant says, this is what I have. She's the one that presented it to me. And I'd remind you that when I asked your client, and if you want me to go back on the record, I will. When I asked your client about a lease, she said she never sent her one. Then when we all of a sudden have it, and Mr. McCoy, let me be real blunt. People can make mistakes in terms of their statements. They can say whatever they want to say. But I got that June 11th statement that says she owes $5,000. Then at some point when Ms. Carterman, when we're in a hearing, brings up that she got a new lease, your client denies that any lease was sent to her.
She was referring to a signed copy of the lease that she had sent out. She's not denying that
Oh, Mr. McCoy, go back and listen to the hearing.
she's not denying that she sent a lease.
She can't now because Ms. Carterman got me the lease.
Where is her copy?
What do you mean, where's her copy? She
Miss-
says she signed it and sent it.
Where is it? We don't have a
Mr.
copy.
McCoy, you can't shift. Can't shift. What I'm indicating to you is this. You're trying to shift everything here. I'm asking very direct questions about what the landlord's conduct was. I ask about a lease. Ms. Cutterman says there's a lease that was sent to her. Your client denies it. Then say, okay, but then what we have, if it's indeed true that Ms. Cotterman signed it, sent it back. If that's indeed true, then the notice on the 5th is invalid.
Why would the notice on the 5th be invalid? If it's-
Because she's led the tenant to believe that her tenancy has continued. The whole theory behind Park Forest.
But she led the tenant to believe her tenancy had continued for 30 days, month to month. And in month to month tenancies, all you have to do is provide a 30-day notice to quit. That notice was.
Which
provided
means,
August the 5th through September the 5th, the 30 days were up, she was entitled to possession. Now, even if there is a.
are you saying the lease that was signed was a month to month?
That's correct, Your Honor. Even if there is a expiration of the prior lease and a holdover tenant, they are generally given a 30-day notice. Here we gave her a 30-day notice.
Is your client the owner or manager of the property?
She's the owner and manager, yes, Your Honor.
So if it begins on 7/1, this lease you're saying was never sent.
She never received it.
Well, she never received it. She intended to send it to her to start a month to month on that day.
That's correct.
Did she send a ledger to Sarah?
You didn't say anything, sir.
Aaron, what was the last ledger that you got from Miss Weinberg?
Checking now, Judge. The last ledger that's uploaded was uploaded on January 28th of this year.
And what does that ledger reflect as owed? Or
Let me download that and take a look. It's a Microsoft Word document. It's not very long. It doesn't have it broken down by month, but it states that Ms. Cotterman owes $950 per month plus a $100 late fee for October, November, December, January, for a total of $4,000. And it's dated January 27th of this year.
which would account for the 3,000 plus in the 2,850 or thereabouts for January. Well, there was a payment in December though, which would have been the 3 and then one more. Got it. All right, thank you, Aaron. What was the purpose in your client presenting a lease to her at the beginning of July? Was that to seek CERA funds?
The answer to that, yes, yeah. To seek CERA funds and the whole purpose, we were talking about, the case was still in court because of damage to the property. And she didn't know how long this case was going to be before we're in this court. And so she hadn't received any money since April. And so what she wanted to do, if this was going to continue on in the future, she prepared a month-to-month lease, and she was going to seek funding for the time that Ms. Cotterman was still in the premises. And that could have been 2 months, 3 months, 5 months. But the whole issue here is that lease was a month-to-month lease. That lease was for July 1 through July 30, and she never received a copy of the signed lease. And so she did the notice to quit. On August the 5th,
Did your client make a representation to CERA that Ms. Cotterman had moved out?
no, she did not. She said that she had given her funds so that she could move out.
in August. Aaron, can you see the entry from August 1st of 2020?
2020,
22.
2022.
Yeah.
Yeah, I see two from August 1st of this year.
Right. Now the second, or maybe the first one, the email to Miss Weinberger. When it says we're in receipt of the CERA recertification, is that the tenant's recertification?
That is correct.
Okay. So then August 2nd. Did they ever receive a confirmation from the landlord that they still own the property?
I don't believe so. Let me go back and see Carmen's note from earlier today. The note from Carmen says that they started reaching out on the 2nd of August, the date that you were just indicating, and as of yet had not had a response. It says that Carmen called her on the 3rd of August to verify if Ms.
Oh, you froze on me. I'm gonna drop him.
Can you hear me now?
Yeah, I can hear you now, sir.
Okay, sorry, my internet is unstable today for some reason. So Carmen called on the 3rd of August to verify if Miss Cotterman still lived at the property and was asked to call back. Carmen later called back and did not have anybody pick up. She sent another note requesting the same verification on August 22nd and received no response.
All right. Thank you.
Yep.
Is that correct? The landlord hasn't responded?
That's correct, all right.
No, folks. The problem is it's going to be stayed. And I'm going to have to look at it under the Supreme Court order. The landlord, once the tenant submits the application, and I'll look closely at it, the landlord, the matter becomes stayed technically at that point and does not move forward until the landlord, if the fault for that staying is the landlord's fault or something the landlord hasn't done under the CERA program. And so let me ask you this, folks. She has currently a CERA application in. Why wouldn't you do something to make sure that that's processed through?
Are you asking my client that, Your Honor?
Yeah, I'm asking both of you.
My clients want to obtain possession of the premises because she has a door that is not repaired and she can't rent out and the upstairs unit is damaged and she can't get in to fix it. So what she wants is to fix both places so that she can rent the lower level and the upper level. Your Honor, we have attached exhibit E, which shows the damage to those premises. And a statement from the repair person who would have been here except his his grandchild had COVID. And he didn't want to expose the court to COVID. I didn't want to get exposed to it either.
I'm trying to figure out what in these 2 months led the landlord to head in what remarkably is an opposite direction. I mean, part of my problem with this whole thing is I can't ignore what apparently is fraud on the program. I also have to wonder come July, when this lease happens, why less than a month later, I have a termination to her. And in that intervening period, just before that, I have no cooperation from the landlord regarding the CERA program.
Your Honor, we were in court on the 28th of, I want to say the 28th of July regarding the damage to the premises.
Oh, I remember.
And the damage to the premises continued, and there has been all kinds of problems or altercations between the tenant and the neighbors and the landlord. So what we're trying to do, my client wants to repair the facilities and move forward. And instead of her getting the opportunity to do that, she's been in court on a regular basis almost every other week. And so when she applied in July, she was applying because she didn't know how long this case was going to last. And she still does not know how long.
But she also understands that under the administrative order, she can't interfere with the tenant receiving CERA funds.
But she can't interfere with a tenant that's violating the terms of the lease. Is that a fact, yeah?
No. Violate. So what term did she violate? I thought you were just issuing a notice based upon the 30-day provision.
And for violating the provisions of the lease.
For the unauthorized person?
I believe that person is in the courtroom, Your Honor.
Okay. You're really going to proceed on an unauthorized person?
Yeah, let's look at this from a procedural standpoint. August,
Okay.
we're gonna say, let's say on July 9th, a new lease was entered, which she didn't receive. But let's say that lease was in place.
Mm-hmm.
And that lease indicates that only one occupant can be in the premises. And that's under F on the lease itself, the new lease.
So where?
Under F.
Where's my proof?
It's attached as Exhibit C, guys.
The proof of the occupant?
Proof is right here.
What is that, though? The proof of, that's proof of the occupant? Where's the proof that they're occupying the premises?
It says, the lease says it's supposed to be one occupant in the premises. And it's our contention. that there are
Okay.
two.
So what proof do you have that there are two?
Well, I have. Ms.
And
Judy Weinberg,
and let me
who's
just
sworn-
ask you this. On what definition are you saying that somebody's an occupant?
I have two, and potentially three, the Ms. Cotterman herself. She's under oath now, you can ask her whether or not there's more than one person that's living in the premises.
Ms. Cotter,
No, he has his own address.
he has another address?
Yeah, he has his own address.
Okay.
And so, our repairman was there and saw him staying there and made representation.
So saw him staying there?
Yes, and Miss,
So is she running a convent?
pardon me?
I mean, why can't he be there?
He's not on the lease, Your Honor, and he lives there.
If he has his own address, then how's he living there?
Well, Your Honor can ask him under oath, Your Honor, about whether or not.
No. Mr. McCoy, for years, prior to donning this robe, I would deal with occupant cases. And so the very first thing that has to happen is one has to define when one goes from being a guest, which I'm sure are not prohibited, to being an occupant. That's the very first thing. Then I have to have proof that that person is there in excess of the time frame that one is claiming forms the occupancy. So my first question would be, at what point, and presuming, I have no idea if he's there or not. You say you got witnesses that are there. At what point does he become an occupant as opposed to a guest?
Certain circumstances, Your Honor, I say that.
So Ms. Cotterman's not allowed to have guests?
Well, she can have guests, but he's not, he would never be considered an occupant. He's always a guest.
So I don't know what that means, Mr. McCoy.
Well, that's what I'm saying about occupant, Your Honor. Occupant, the distinction between an occupant and a guest, I don't understand what that means. If a person is living in the premises on a regular basis.
Well,
and
there we go. That's precisely what I'm indicating. How are you defining occupant? What are you defining? You can call it whatever you want, but how are you defining regular basis? I mean, how am I supposed to decide that?
I guess you're supposed to take testimony on it to find out.
Yeah, but what I'm saying is, what proof do I have? I first have to figure out really whether or not I have a tribal issue. I don't even know that there's a tribal issue because I don't know what standard you're operating on, Mr. McCoy.
I'm operating on the standard that there is no lease. If there's no lease, then there's a 30-day notice to quit. She received a 30-day notice to quit from August the 5th through September the 5th.
You're just going around in circles.
And you're entitled to possession.
Whenever you don't like an issue I raise, you go to something else. You have put on there that it's an occupant. So I want to know how the landlord is defining occupant.
It's whoever is on the lease.
I don't understand. Lisa texted me. Do we have an answer to my question?
You're trying to distinguish between occupant of the premises and guests. And you said, what kind of proof do we have that the
All right. With the latest report on the Washtenaw State Mission session.
Okay, we're back on the record in Weinberg versus Cotterman in both cases. Had an opportunity to speak with both parties, and the court's going to, from my understanding is both parties are accepting that the defendant will have until November 30th to reside in the premises. That each party, without necessarily a guarantee as to the result on the CERA program, will cooperate in the continuation of the to decision in CERA funding. All right. And we explained and had a conversation with both sides as to the consequences of each of those and where that may put them come the end of November. I will set a new date in this matter because I want to check on it. I will set that for October 21st. Okay. At 3:30. That will be by Zoom. Okay. Weinberg and Mr. McCoy, is that a correct understanding of the agreement of the parties?
Yes, Your Honor, I think that's an accurate assessment. Really going from here in the agreement that was discussed.
All right. Ms. Cotterman, is that your understanding of the agreement? Ms. Cotterman, since you are unrepresented, do you have any questions whatsoever as it regards this agreement? No? Okay, very good. Well, like I indicated to each party, I'll be checking in without bringing you guys back, but then we'll come back on the 21st and make sure we know where we are. All right? Everybody have a great evening. Thank you.
Thank you, Your Honor.
Thank you. Is that it for us? 14A stands adjourned.